This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Welcome everybody. I'm Leonard French, your favorite copyright attorney, and we have a real special one for you today. We wanted to do a live stream about this. TAC has graciously highlighted out this lawsuit. This is a decision of the Superior Court of Justice of Ontario, Canada, and this is Wiseau Studio, also known as Tommy Wiseau, doing business as Wiseau Films, versus a Room Full of Spoons documentary, which was about the Room movie that Tommy Wiseau is famous for. This is the sort of smash hit or box office bomb that released. When did it release? I actually haven't seen it in a while, but it didn't do too well on its own, but for being such a terrible movie, it seems to have caught a whole fan base that just loves to talk about it and follow it and watch it for how horrible it is. So someone wanted to make a documentary about that. This Room Full of Spoons Inc. and Richard Harper, who you're going to hear referred to throughout this thing. And so since 2017, Tommy Wiseau has been maintaining this lawsuit against Room Full of Spoons. You might call it a slap suit, a strategic lawsuit against public participation. He was trying to get the documentary shut down, or at least have the documentary better reflect what his desires were for the documentary. So, make him look better, that kind of thing. I'm going to stop explaining it because the judge does a great job. Strap in. This is going to be about an hour, I think. But like I said, we've highlighted it out, so we're not going to go over the whole thing. We're going to go over the juicy parts that I think you'll really enjoy. So without further ado, and by the way, you know what? Before we go over it, let's go over the Room Full of Spoons website, where they are claiming victory. The plaintiff's claim is dismissed, the counterclaim is granted, and plaintiffs shall pay defendant Room Full of Spoons $550,000 US in compensatory damages, plus 200,000 Canadian, which is about $150,000 US. The defendants are entitled to their costs. The plaintiff is Tommy Wiseau. The defendants are yours truly, Room Full of Spoons. We won, and there is their legal team. I love that they have to wear these little frilly necktie things. Of course, you could say that about any necktie, so I can't really throw stones. So without further ado, let's see what they won. In June 2003, the plaintiffs, Tommy Wiseau and Wiseau Studio LLC, released a feature film called The Room. It was a box office flop and received terrible reviews. Entertainment media described the film as a movie that prompts most of its viewers to ask for their money back before even 30 minutes have passed. A sign on the ticket booth where the film was playing read, "No refunds," and contained an excerpt from a review that said, "Watching this film is like getting stabbed in the head." Despite these reviews, or perhaps because of them, the film developed a cult-like status. Tommy Wiseau, who wrote, produced, directed, and starred in The Room, has become somewhat of a celebrity, often attending screenings to promote the film, meet with fans, engage in question and answer sessions, and sell merch. In 2011, Wiseau's co-star and friend Greg Sestero wrote a nonfiction book about the making of The Room called The Disaster Artist: My Life Inside the Room, the Greatest Bad Movie Ever Made. A film adaptation of the book was released in 2017 to broad critical acclaim. Its star, James Franco, who played Tommy Wiseau, received a Golden Globe Award for the Best Actor in a Musical or Comedy. Wiseau was supportive of The Disaster Artist. He provided on-the-record interviews to the author as well as access to the original script of The Room, photographs, and behind-the-scenes production footage. Wiseau entered into licensing agreements with the filmmakers for use of footage from The Room and appeared in The Disaster Artist himself. Another film was also made about The Room, however, which gives rise to this lawsuit. In 2010, the defendant, Richard Harper, became a fan of the film after attending a screening in Ottawa. In 2011, together with his friends and fellow defendants, Fernando Ferrero McGrath and Martin Ratchicott, Harper sponsored a screening of The Room in Ottawa, which included an appearance by Wiseau. Harper and his friends hit it off with Wiseau, and after spending time with him in Ottawa and Toronto, and with Wiseau's encouragement, they decided to create a documentary about The Room and its fans. However, not long after, Wiseau said he was no longer interested in participating in it. Over the next few years, Harper, Ferrero McGrath, and Ratchicott worked on the documentary, investing their own money and raising money through a crowdfunding website called Kickstarter. The documentary, entitled Roomful of Spoons, was completed in January 2016. It tells Richard Harper's story of his interest in The Room and in Tommy Wiseau, how the film was made and reactions to it. It includes interviews with many members of the cast and crew, fans, film professors, critics, and others. The documentary also addresses questions about how The Room was funded and Wiseau's background, including where he was born and how old he is. Questions raised in The Disaster Artist, but about which Wiseau is secretive. In 2015, Harper had tried to negotiate a license agreement with Wiseau, as the documentary includes many clips of The Room. No agreement was reached, mainly because Wiseau wanted editorial control over Roomful of Spoons, and the defendants decided to proceed without an agreement. Wiseau, even before seeing the documentary, then began a campaign to denounce the documentary, accusing the defendants on social media of copyright infringement and illegal downloading, and sending letters to potential exhibitors of Roomful of Spoons threatening litigation. This resulted in many canceled screenings, including a planned North American tour to 25 cities and to cities in Australia, Poland, and the United Kingdom. Nevertheless, in 2016 and early 2017, the defendants were able to arrange showings of the documentary at some film festivals in North America and Europe, and it received positive reviews. The defendants, who had now been joined in their project by the defendant, Richard Towns, entered into negotiations with a California film distributor, Gravitas Ventures, for a distribution agreement. The defendants also sent a copy of Roomful of Spoons to Wiseau in February 2016 in the hope that any concerns he had about the documentary would be put to rest. Following further correspondence between Wiseau and the defendants in the spring of 2017 and an agreement by the defendants to delay the release of the documentary for 2 weeks in early June 2017, Wiseau commenced this action by bringing an urgent motion ex parte, which means without the opposing party, for an injunction restraining the release and promotion of Roomful of Spoons. So that is a typo. It's not Roomful of Spoons, it's Roomful of Spoons. Just in case anybody cares. The injunction was granted by Justice Diamond on June 14th, 2017, and was continued by Justice Justice Akbar on June 27th, 2017, who adjourned the matter to October 10th to allow the defendants time to retain counsel and prepare a response in the action. And on the motion for the injunction, Wiseau asserted and continues to assert that Roomful of Spoons breaches the plaintiff's copyright in The Room, including Wiseau's moral rights, which are like his rights to not have his work altered or not have his work displayed in a mocking light or something. Not the same thing as not criticizing it or mocking him, but rather an original. It's more complicated than that, so just let me have that simple definition of it. And that the defendants have unlawfully invaded Wiseau's privacy, that they've misappropriated his personality, and committed the tort of passing off their work as his. Although pleaded and relied on in the injunction proceeding, claims for misrepresentation and breach of contract were simply not pressed at trial. So in other words, they didn't give evidence and testimony in furtherance of those claims. After a hearing on October 10th, 2017, the injunction was dissolved, and on November 11th, Justice Kanan found, among others, that the plaintiffs failed to make a full and fair disclosure to the court on the ex parte motion, that the court was misled, and that on the evidence before him, the test for an injunction was not satisfied. Following an unsuccessful motion for leave to appeal by the plaintiffs, by Wiseau, and after the defendants indicated an intention to bring an anti-SLAPP, or strategic litigation against public participation, lawsuit or motion, so an anti-strategic litigation against public participation. One second. So a SLAPP lawsuit is like, if I don't like what you had to say about me, I assert copyright to what you produced. Let's say it was a news piece or a documentary about Leonard French, and it said some nasty things or something. Maybe I have the barest minimum, or if any, claim of copyright infringement on something. Of course, it's probably a fair use that they are making criticism and commentary about me, but no, I'm going to file a lawsuit to try and stop them, and maybe I have more money than they do, and maybe I can just keep on fighting the lawsuit, and they're just going to eventually have to give up because they don't have a choice. That's a SLAPP suit. That's a strategic lawsuit against public participation. So here, the defendants are going to make a motion against Wiseau's SLAPP suit. The motion pursuant to the the Protection of Public Participation Act. The parties agreed to an early trial date and to filing affidavits which would serve as the direct evidence at trial. I will deal with more detail with many of these steps later in these reasons. In the meantime, because of the injunction and outstanding action, Room Full of Spoons has not been released or shown anywhere since the litigation was commenced. No distribution agreement has been concluded, and the defendants lost the opportunity to release the film while The Disaster Artist was having its successful run in late 2017, which would have created interest or buzz in Room Full of Spoons. The case was tried before me over 2 weeks, commencing January 6, 2020. For the reasons that follow, I dismiss the plaintiff's action in its entirety. Further, I grant judgment in favor of the defendants on their counterclaim, which arises from the improper obtaining of the injunction, for which the plaintiffs agreed to indemnify the defendants as a term of obtaining the injunction. So it's similar in the U.S. Remember, this is a Canadian lawsuit. Similar in the U.S., the plaintiff or the moving party that's asking for an injunction, if they're winning an injunction, they're going to have to post a bond of some kind, money saying, here's money that can go to the defendants or the winning party if we lose the injunction motion, or if we lose the case too. And other wrongful acts taken in this litigation, and to prevent the release of Room Full of Spoons. I award the defendants $550,000 US in general damages and an additional 200,000 Canadian dollars in punitive damages. The Room is a 99-minute-long feature film that was written, produced, and directed by Wiseau. It tells the story of Johnny, a banker, and his fiancée, Lisa, who no longer loves Johnny and is sleeping with Johnny's best friend, Mark. It is a typical love triangle. Wiseau stars in the production in the leading role of Johnny. Sestero plays the other leading role as Mark. There is no evidence, and it remains a mystery, how The Room, which reportedly cost about $6 million to produce, was financed. It remains a mystery how it was paid for. The film is described in promotional material, such as on the back of the DVD package, as an electrifying American black comedy about love, passion, betrayal, and lies. It's what happens in real life. You could be with your loving woman and all of a sudden, boom, she's in bed with your best friend or family member. Following its release in 2003, The Room played for 2 weeks at a Los Angeles cinema, grossing $1,800. In an entire 2 weeks. Critics panned the film. In addition to the reviews quoted above, the BBC described the film as not just bad, it's intoxicatingly awful. Entertainment Weekly described it as the Citizen Kane of bad movies. The Huffington Post called it a 99-minute train wreck. Over time, however, The Room has developed a cult-like following, and, as the BBC has reported, so has its mysterious creator, Tommy Wiseau. There are monthly viewing parties in at least 60 theaters all over the world. Wiseau often attends these screenings and is treated like a celebrity, signing autographs, posing for photographs, selling The Room, and Wiseau-related merchandise, including t-shirts and Tommy Wiseau, underwear. At screenings, fans often come dressed as characters in the film, and they laugh, heckle, and throw things at various times during the film. This is because the film is so bad. Unlike the promotional statement on the DVD that it is a black comedy, reviewers have commented that there are very few jokes in the film. Its production quality is poor, the script and acting are wanting, with plot lines that go nowhere, and there are punishingly long sex scenes. As the BBC put it, The Room is a car crash of incompetence and catastrophic misjudgment. Mystery around Wiseau is also part of the attraction to fans of The Room. Tommy Wiseau, like his character Johnny, has long hair, wears wraparound sunglasses, and speaks English with a strong accent. Again quoting the BBC article, with the luxuriant, suspiciously black mane of Kiss's Gene Simmons and the heavily accented slur of a drunk Count Dracula, Johnny has to be cinema's least convincing banker. However, Wiseau describes himself as a proud American who claims to have grown up in Louisiana and refuses to disclose his age or how he paid for the film.
And yes, in case you're wondering, the judge did have to watch the film because it was entered into evidence.
And I see YouTube has held the punishingly long sex scenes line. Let's clear that up. All clear. The defendant Harper discovered The Room in 2010 and has attended at least 25 showings of the film. Sorry, you're not even close to the number of times I've watched The Office yet. Wiseau has been present at approximately 12 of these screenings. Harper introduced the film to his childhood friends, Ferrero McGrath and Ratchicott, and in April 2011 they sponsored a screening of The Room, sharing the cost of Wiseau's $1,500 appearance fee with the owner of the Mayfair Theatre in Ottawa, Lee DeMarbre. They got along well with Wiseau during his time in Ottawa, and Wiseau invited Harper and his friends to come to Toronto to help Wiseau with several screenings at the Royal Cinema, where they assisted in selling Wiseau's merchandise. They shared meals with Wiseau, who paid for their travel and accommodation, and unexpectedly gave each of the three defendants $80 in cash as well. You hang out with Tommy Wiseau, and he's like, "Hey kids, here, have some cash." Sure. Okay. While in Toronto, April 23rd, 2011, Harper raised the idea of making a documentary about The Room and its fans. Wiseau was supportive of the project and agreed to participate in it. He suggested that they begin filming the documentary at the upcoming screening of The Room at the Ziegfeld Theater in New York City. Harper, Ratchicott, Ferrero McGrath... Why can't we just call him McGrath? Like, why does this one guy have to have a longer name than the others? Two hired assistants all rented a van and film equipment and drove to New York in June 2011. However, while on their way to New York, Harper received an email from John on behalf of Wiseau withdrawing the invitation and advising that Wiseau was no longer interested in participating in the documentary. John, who may well be Wiseau using an alias, indicated that Wiseau would not be in New York in any event until the next day. The defendants, having made the time and financial commitments to go to New York, continued with their trip. Upon arriving in New York City, they went to Times Square to obtain B-roll footage, which is like extra footage that you use to fill in and show settings and things like that.
Yeah, we're here. We might as well just get some footage from...
Yeah, I do this with the dogs on our stream. While doing this near the Ziegfeld Theater, Ferrero McGrath noticed Wiseau in a sandwich shop, which was surprising, given the email that said he would not be in the city until the next day. However, when the defendants approached Wiseau, he quickly left the sandwich shop, stating he was very busy. Some of this was caught on camera by Ratchicott and was used in the documentary. While it was asserted that the defendants chased Wiseau, there is no evidence from Wiseau on this point. Harper and Ratchicott strongly denied it in cross-examination, and Ferrero McGrath was not even asked about that encounter. Harper, Ratchicott, and Ferrero McGrath attended the screening of The Room in New York City. They bought their own tickets, they interviewed fans on camera. Some of this footage was also used in the documentary. over the next 4.5 years until early 2016, the defendants worked on the documentary and its scope evolved. They interviewed all the actors who played named characters in the film other than Wiseau and Sestero, who refused to participate, and several members of the crew of The Room, including the camera operators, production assistants, the script supervisor, and the composer. The defendants also interviewed fans, including Patient Zero, who discovered The Room and initiated its cult-like following, and film critics and film professors. They also investigated Wiseau's background, including traveling to Europe and tracking down his origins in Poland, interviewing his family there and determining his age. The 4 individual defendants invested approximately $74,000 of their own money in the film and raised $26,000 through Kickstarter, a crowdfunding website, which funds were primarily used to pay for the defendants' travel to Europe to investigate facts about Wiseau's origins. The name of the documentary, Room Full of Spoons, stems from a flaw in the film. There are framed photographs in the living room set where much of the film occurs. However, one of them has a stock photo of a spoon, as it appears no one put an actual photo in the frame. Fans noticed this, and whenever the photo of the spoon appears, fans throw spoons at the screen. Someone mentioned to the defendants that following a showing of The Room, all you are left with is a room full of spoons, and hence the name. That's pretty cool.
Amazing.
That's awesome. I'm gripped. We have like 40 pages to go on this. Just 2 days after the defendants' Kickstarter campaign was launched on February 20th, 2015, someone called Rawl, acting for Wiseau, but which may also be an alias for Wiseau, sent emails to Harper demanding that the defendants stop using material from The Room in the documentary and that all references to Wiseau be removed from the Kickstarter campaign. On March 3rd, 2015, Wiseau filed a complaint with Kickstarter alleging that the defendants had stolen footage and were making false statements about Wiseau and his business. The complaint also asserted that the defendants needed permission to use any footage filmed at screenings. As a result of the complaint, Kickstarter removed the trailer for the documentary from the campaign, which reduced the number of pledges received by the defendants. Harper spoke to Wiseau on the phone on March 3rd, 2015, proposing that they negotiate a license agreement. The parties exchanged email correspondence and a draft license agreement the next day. However, Wiseau demanded a large sum for each clip of The Room used in the documentary, and the draft agreement prepared by him provided that he would have final approval of the documentary, which required that the film be focused on the fans, rather than on The Room or Wiseau. These terms were unacceptable to the defendants, and Harper advised Wiseau that while they had no difficulty allowing him to view the film before the public release so that he could raise any concerns, they were not willing to agree to give up final cut privileges to him. Wiseau reacted, beginning in April 2015 and continuing until February 2016 by posting a 3-part series called Shame on You on YouTube and his website. He also caused the series to be aired before theater screenings of The Room. Although somewhat difficult to follow from the material before me, the Shame on You series was an attack on the defendants and their making of the documentary, and alleged that the defendants were violating copyright laws and committing other wrongs. Terms used in the campaign included stealing, illegal downloading, and fraud. However, the campaign did not appear to name the individual defendants or otherwise identify them other than through the name of the documentary, Room Full of Spoons. During this period, Wiseau, through Rawl, continued to demand payment for the use of the clips from The Room in the documentary. He also demanded the defendants not use his name and that promotional posters be changed. He asserted copyright and trademark infringements. Wiseau complained that Harper and his colleagues were being very disrespectful and that their research was going in the wrong direction. The documentary was completed in January 2016. Room Full of Spoons is 109 minutes long. It contains a total of about 7 minutes of clips from The Room, all of which are short and used in conjunction with commentary, or are the subject of commentary directly afterwards, often introduced by an interviewee or the narrator. One of the plaintiff's witnesses, documentary filmmaker Cynthian Sharp, Cynthian, what a cool name, testified that the story arc of the documentary has 3 themes. 1, the experience and culture surrounding the room and its fans. 2, the making of the room as experienced by those involved. And 3, information about the mysterious Tommy Wiseau. Harper summarizes the documentary as an in-depth commentary about the cult-like phenomenon of the room and its creator, Tommy Wiseau. Having watched the documentary and the room, I, the judge, find the descriptions of it by Sharp and Harper above to be apt. Further, rather than seeking to replace the experience of the room, Roomful of Spoons studies and celebrates the phenomenon and the community that has grown up around it. The documentary complements the original work, which would explain why several theaters and film festivals have sought to host double feature screenings. Oh, that's cool. So you go and watch The Room and then watch Roomful of Spoons. That's really cool. On February 23rd, 2016, Harper provided Wiseau with a courtesy copy of Roomful of Spoons. Wiseau, through Rawl, had numerous objections to the documentary. These included the references to his origins, original name, and birth date, which he did not dispute as inaccurate, the amount of time devoted to his family in Poland, reference to a California civil court action against him for fraud, and claims by Sandy Schleier, credited as a script supervisor of The Room, that he actually directed 90% of the film.
There's some weird names in this lawsuit, aren't there?
Yeah, right. Wiseau complained that the documentary was too negative and said that it could be framed with more positivity by at least 60%. 60%. He asked that there be, at the end, that it say something upbeat and positive. In addition, he noted that there were over 65 clips from The Room and Wiseau Films' original material, including over 24 pictures. Wiseau suggested that if they addressed his objections, he might approve other clips. The defendants reminded Rawl that they had sought to have a license agreement, but in any event took the position that the clips are covered under fair use. Even before the documentary was completed, theaters in the UK and Canada had asked to screen it. In 2016 and 2017, Roomful of Spoons was screened at 10 film festivals in Europe and North America. This was intended to promote the film in order to obtain a distributor. It was well received. The Huffington Post, in an article that provides a good summary of The Room, the phenomenon it has created, and the documentary, describes Roomful of Spoons as follows. Along with capturing the excitement and joy the movie has brought to those fans all over the world, Harper's documentary solves a long list of mysteries fans have wondered about The Room for years. It is a very impressive feat of reporting. Ottawa Life magazine referred to the documentary as an encyclopedic reference guide to everything a fan of the film would want to know. The lead actress in The Room, Juliette Danielle, who plays Lisa, described the purpose of the documentary as a love letter to The Room, saying the team had done their homework and talked to everyone involved in the project. Nonetheless, Wiseau, or Rawl on his behalf, escalated his attack on the defendants after the festival screenings. Even before obtaining a copy of Roomful of Spoons, Wiseau sent emails to exhibitors and potential distributors of the film, alleging copyright infringement and illegal downloading of The Room, demanding that the film not be shown, and demanding that Wiseau's image or references to The Room not be used in promoting Roomful of Spoons. In cross-examination, Harper confirmed much of this campaign by Wiseau, as he saw many of these emails and was told by several programmers that if they screened the documentary, Wiseau would not let them screen The Room at their theaters. Indeed, the record contains an excerpt from The Guardian reporting that Wiseau had threatened legal action in Australia, stating, "World's worst filmmaker forces Sydney Underground Film Festival to cancel its screening of documentary about cult film." So as we go, I saw some questions about how in the world this got up to $700,000 in damages. That's why. They had a successful documentary, and he managed to shut it down. Although Harper made further efforts to negotiate a resolution, Wiseau escalated matters, retaining counsel in California and in Ontario, sending cease and desist letters, making additional demands to change the documentary. The defendants accepted many of his demands for changes in an attempt to avoid a dispute, but Wiseau continued to make additional demands. As subsequent events confirmed, Wiseau did whatever he could to stop the release of the documentary. As a result of Wiseau's threat to potential exhibitors, a planned tour of 25 North American cities and screenings scheduled in Australia, Poland, and the United Kingdom in 2016 and 2017 were cancelled. Several cinemas in Canada and the UK had proposed doing double features of The Room and Roomful of Spoons, but these did not go ahead either. The defendants incurred significant expenses and effort in arranging these screenings and accompanying media opportunities, all of which were lost. In 2017, the defendants were in discussions with Gravitas Ventures to complete a distribution agreement. As witnesses for the plaintiffs agreed, Gravitas is a respected independent film distributor in California, which had offered the defendants a distribution agreement for a term of 15 years, covering the United States and Canada. Gravitas was one of a number of distributors to reach out to the defendants, and expressed excitement at the prospect of releasing it around the time of The Disaster Artist in late 2017. The uncontradicted evidence of the defendants is that the agreement was not concluded with Gravitas due to the legal steps taken by Wiseau in June 2017 discussed below. Harper and Ferrero-McGrath both were cross-examined on this issue and confirmed that a deal with Gravitas would have been signed if Wiseau had not sued them. In April and May of 2017, the defendants engaged in further discussions with Wiseau's lawyers at Bearskin and Parr LLP, a well-known intellectual property law firm in Toronto. The defendants made a number of additional... Let me just back up for a second and comment. It's a Canadian law firm named Bearskin. Come on, that's pretty awesome. The defendants made a number of additional changes to the film in response to Wiseau's demands. Also, at Wiseau's request, the defendants removed images and videos of Wiseau on social media and advertisements for Roomful of Spoons in an effort to reach a resolution. Although Wiseau complained that the promotional material suggested that he endorsed the documentary, in fact, the defendants' materials made it clear this was not the case. They described the film in the trailer as the documentary Mr. Wiseau does not want you to see. Didn't we have a case we did a couple years ago where they said it's not this, like, you know, it's everything that you want, but it's not that. So then when they got sued for trademark infringement, the infringing party can say, hey, we literally said the words, it's not that.
All sesame, no street.
All Sesame, no street. That's what it was. It was the anti-Sesame Street musical or whatever, right? Or movie or something.
Happy Time Murders, I think.
The Happy Time Murders, right? The movie. Right, I'm confused with Avenue Q. Roomful of Spoons was to be released on June 1st, 2017. However, on May 19th, Wiseau's Ontario lawyers threatened to bring an injunction application unless the release was postponed by 2 weeks, which was agreed to by the defendants as a gesture of good faith in order to continue to pursue a settlement of Wiseau's complaints. The defendants' social media platforms promoting the documentary, developed at considerable expense on Facebook, Twitter, Instagram, YouTube, confirmed that the release was pushed back to June 15th, 2017. Rather than negotiating, however, the plaintiffs used the delay to prepare a surprise injunction application. On June 14th, 2017, Wiseau's lawyers brought a motion to this court without notice in Toronto, seeking an injunction to prevent the release of Roomful of Spoons. As Justice Kanan explained in his subsequent decision lifting the injunction, Bearskin and Parr gave a couple hours' notice to a lawyer in Ottawa who had acted as a corporate solicitor for the defendants in the past. That lawyer could not accept service, and the motion on June 14th proceeded as an ex parte motion. Justice Diamond granted the injunction and directed that the matter be addressed in court again on June 23rd. On that date, some of the defendants appeared, but they had not had the opportunity to retain counsel and sought an adjournment to do so and to file materials. Justice Akbar Ali therefore set a return... I'm just going to call him Justice Akbar. Therefore set a return date of October 10th, 2017 to argue the matter, and the interim injunction continued until then. While the injunction was in effect, another film about the room was released called The Disaster Artist. That film, a $10 million Hollywood production produced by and starring, among others, James Franco, Zac Efron, and Seth Rogen, was based on Sestero's successful 2013 book, The Disaster Artist, My Life Inside the Room, the greatest bad movie ever made. As a result of the injunction and litigation by Wiseau, the defendants were unable to complete the distribution agreement with Gravitas, which advised that it was not prepared to move forward with an agreement until the claim was resolved. The defendants have not been able to show the documentary or obtain other offers for distribution. The defendants were also unable to distribute DVDs or otherwise release copies of the documentary while litigation continued. This created problems for them with people who had provided money supporting the project on Kickstarter, who had expected to receive copies of the documentary in return for their investment. Some contributors asked for their money back. Due to the timing of the injunction and the continuing lawsuit, Roomful of Spoons lost the opportunity to be released around the same time as The Disaster Artist. At trial, the defendants led uncontroverted evidence from the expert in calculating intellectual property damages, Doug Bania. His view was that had Roomful of Spoons been released as planned prior to The Disaster Artist, it would have benefited considerably from the marketing and media buzz from The Disaster Artist at the time. Based on his analysis of other documentaries linked to feature films, Roomful of Spoons would likely have earned revenues of approximately US $1.1 million, of which the defendants would have received about $660,000 US dollars. On October 10th, 2017, the continuance of the injunction was heard before Justice Kanan. Prior to the hearing, Wiseau failed to attend for cross-examination on the affidavit he had filed in support of the injunction. That means he didn't show up for his deposition. This prevented the defendants from obtaining any financial or other disclosure from Wiseau as to his income from the room and The Disaster Artist, and how, if at all, that may have been impacted by the release of Roomful of Spoons. To this day, Wiseau has not provided any financial disclosure or information about his agreements regarding his life rights or about any income he derives from the room, The Disaster Artist, or anything else. In detailed reasons released on November 1st, 2017, Justice Kanan dissolved the injunction because, in his view, the plaintiffs failed to make proper disclosure on the earlier ex parte attendances, and because they failed to persuade him that they should be granted an injunction on the traditional three-part test, which requires them to demonstrate a serious issue to be tried, that they will suffer irreparable harm if an injunction is not granted, and that the balance of convenience favors granting an injunction. Justice Kanan found that the plaintiffs fell seriously short of the disclosure required for an ex parte injunction. He noted that Wiseau painted a picture of himself as a serious filmmaker, complaining that the documentary mocks, derides, and disparages the room, casts aspersions on Wiseau, and invades his privacy and breaches copyright law. However, Kanan found material non-disclosure on each point. Wiseau had misled the court, he held, because of his assertion that the documentary said he was a drug dealer, which is not what was said, just that it was one of the rumors as to how the film had been financed. Wiseau also did not tell the court that there is mystery around the financing of the room, a mystery that Mr. Wiseau does not clear up, but seems to foster as part of his image. With respect to the invasion of privacy claim, Wiseau had complained that the documentary alleged he had a sexual relationship with Sestero. Justice Kanan noted, quote, "The documentary makes no such allegation." Rather, it notes that one actress commented, "A couple of others seemed to think they were a gay couple," but then adds that Sestero seemed to want to follow Mr. Wiseau along like a younger brother. Further, Wiseau did not disclose to the court that Sestero's mother asked him not to have sex with her son, a conversation described in Sestero's book, published in 2011. As to the breach of copyright claim, Justice Kanan notes that Wiseau told the court that the documentary contains 7 minutes of excerpts from the room, but failed to disclose the relevant fact that the room has been available in its entirety on YouTube for approximately 4 years, and Mr. Wiseau has not taken any steps to have it removed from YouTube before obtaining the ex parte injunction. Further, as the judge notes, Wiseau did not draw the court's attention to the fact that he would not lose exclusivity of copyright if the defendant's use of excerpts from the room amounted to fair dealing, which is what Canada calls fair use. There are various treaties, copyright agreements and treaties around the world. The Berne Convention on Copyright, the World Intellectual Property Organization Treaty. I think there's one more that I'm forgetting. And basically the whole world, the whole first world, has agreed that copyright should include something along the lines of fair use. And they can, instead of the treaties telling the different countries, you must enact a law that says this, they say, you must enact the law that enacts fair dealing. And then the different countries have to go and enact their own rules, which is why it's called something different in the UK and Canada than it is in the US. Mr. Wiseau was well aware that the defendants were relying on the concept of fair dealing. They had raised it with Mr. Wiseau's lawyers as early as April 2016. Due to the material non-disclosure by the plaintiffs, Wiseau, Justice Cannon awarded costs to the defendants on a substantial indemnity basis in the amount of almost $100,000, inclusive of disbursements and taxes. Wiseau unsuccessfully sought leave to appeal the setting aside of the injunction. The divisional court dismissed his motion for leave to appeal. However, prior to that motion, the parties attempted to reach a settlement, and the defendants moved unsuccessfully to enforce what they believed to be a settlement. So in other words, they settled the matter with Mr. Wiseau, who then apparently didn't fulfill his side of the bargain, and then the defendants were unable to enforce the settlement. So they didn't get paid, basically, is what I think that says. In early 2019, the defendants proposed to bring a motion to dismiss the action pursuant to Ontario's anti-SLAPP law, the Protection of Public Participation Act. However, following a case conference in February 2019, the defendants agreed not to bring the motion if the matter could be tried quickly. Justice Cannon, with the agreement of the parties, then set a schedule for the discoveries and the exchange of affidavit evidence, which would constitute the parties' evidence in chief at trial, with a view to having the entire matter heard in the fall of 2019. Wiseau sought on several occasions to delay the schedule and to adjourn the trial, including bringing a motion December 10, 2019, which also included a request by Wiseau to have all witnesses testify in chief, even though both sides had filed affidavits from their witnesses, so making the witnesses come to the court to testify when their testimony is already in writing, sworn under oath, and taken properly in a deposition. Also, as the endorsement records, Wiseau asked Justice Cannon to direct the Crown, the prosecution, to prosecute the defendants for perjury based on their affidavits in an attempt to adjourn the trial. On December 10th, Justice Cannon directed that the trial would proceed on January 6, 2020, and set out a schedule for the progress of the trial. On December 30th, 2019, Wiseau brought a last-minute motion to adjourn the trial on the basis that he did not have counsel. This too was refused by the judge, who noted in an endorsement dated December 31st that the position the plaintiffs found themselves was a situation entirely of their own making, and one about which I have warned Mr. Wiseau on many occasions. Justice Cannon noted that since February 2019, he had dealt with 3 different motions by 3 sets of counsel to be removed from the record. In other words, 3 attorneys got hired and then fired, or they didn't get paid or something, and they withdrew. In dismissing the motion to adjourn, Justice Cannon stated, to use Mr. Wiseau's language, it would be a major disservice to justice to allow him to delay access to justice to the defendants or others in the litigation system simply because he refuses to deal with lawyers on ordinary commercial terms. Yeah, that means he didn't pay his lawyers. That's what that means. He tried to make deals with lawyers that lawyers did not want to make. We're smart, us lawyers, and we're not going to make deals with you that are against our own best interests. And if we do, you might not want to hire that lawyer. However, Wiseau was represented at his motion to adjourn on December 31st by Daniel Brinza, who appeared on a limited retainer to seek the adjournment. That means he's not in for the whole case, he's just for the one hearing or something, some limited representation. Justice Cannon noted that Mr. Brinza was the 6th counsel to be retained by the plaintiffs. Mr. Brinza stated that he did not have sufficient time to prepare for a trial commencing a week later. At the motion on January 3rd, 2020, Mr. Brinza argued that before Justice Kanan that Wiseau would be prejudiced by being forced on to trial without counsel. In addition, the total withdraw document in which Mr. Brinza had no involvement was reviewed. It attacked the Ontario justice system for, among other things, being stacked against foreigners and self-represented litigants. Justice Kanan again reviewed the history of the proceeding in rejecting the plaintiff's submissions. Of particular note was that in seeking to withdraw this action, the plaintiffs disclosed that they intended to bring a new action in another jurisdiction, presumably in the United States, for the same relief. Justice Kanan noted that the result of that would be that after years of initially obtaining an injunction and then pursuing the action for 2 years, which had prevented the defendants from releasing their film, the plaintiffs would have deprived the defendants of an adjudication and would force them to wait another undetermined period of time until the plaintiff's new action is resolved. Although it was suggested by the plaintiffs that this counterclaim could still proceed, Justice Kanan found that to be inappropriate, as the issues in the counterclaim are intricately bound up with the main action and require the issues in the main action to be determined. The trial then commenced on January 6th. Mr. Brinza appeared on behalf of the plaintiffs and advised that he was retained for the trial. However, Wiseau, who was expected to be the first witness, was not present. I was advised that he did not intend to come until the second week of trial. Mr. Brinza said that Wiseau had some concerns for his safety, asserting that he had received threats and that some of the defendants have an unhealthy obsession with Wiseau, which apparently made him feel insecure. No evidence was led to support these assertions, nor was it explained how this prevented Mr. Wiseau from coming in the first week of trial, but not the second week. Wiseau's unavailability in the first week, and now apparent availability to attend in the second week, was also inconsistent with what Wiseau had told Justice Kanan about his availability when the trial date was set, in June 2019. During Wiseau's cross-examination, reference was made to documents in an action or other lawsuit brought against Wiseau in the Superior Court of the State of California by Frederick R. Litsky, let's call him that, whose wife, Chloe Litsky, is identified as an executive producer of The Room. The claim alleges, among other things, fraud against Wiseau. Wiseau's counsel objected to this evidence. Wiseau himself also took issue with references to the court, pleading when testifying, arguing that the case was closed. One of his court documents, a sworn declaration by Wiseau, had been previously produced and was included as an exhibit to Harper's affidavit provided to Wiseau months before trial. No objection by Wiseau at the time. Wiseau's cross-examination concluded on Wednesday afternoon, January 8th. The following morning, before re-examination commenced, Mr. Brinza presented me with a motion for a mistrial and an affidavit which Mr. Wiseau had prepared himself in his hotel room overnight, informing me that the website for the California Superior Court had blocked access to the file, and the only search result for the case returned the message, "Case restricted pursuant to court order." Wiseau went on to state in his affidavit that his belief is that a crime for anyone to publish anywhere a document related to that case, or it is a crime. As well, the two documents from the case marked as exhibits appeared to have been obtained from a website called plainsight.org, which Wiseau's research showed is a privately operated website that collects and posts documents, including court documents, that might not otherwise be accessible, and seeks money to then remove such documents. Kind of like those mugshot sites. I deferred a final decision on the use of the court documents until Monday, January 13th. At that time, I received a formal motion to expunge all references to the California action, and a second affidavit from Wiseau, dated January 12th, prepared after he returned to California after testifying. The affidavit confirmed that Wiseau had been aware of the defendant's access to the California court record since he first saw the documentary in February 2016, as it contains a shot of one of the court documents. However, Wiseau asserts that he advised Harper of the order sealing the court file and that any publication of it would be a contempt of court. Nevertheless, Wiseau took no steps to enjoin the release of the film on that basis, or any other steps to enforce any sealing order. And by the way, most of the time when a court document is sealed. It's the parties that can't post a document. If somebody else already has the document, the court doesn't really have jurisdiction over non-parties. Even if you're in the courts, even if you're in the county where the court is, or you're located in an area where the court does have jurisdiction, you really don't get brought under such a court order so easily. So I'm not sure that Tommy was right there. Big surprise, I know. Wiseau's January 12th affidavit also included a copy of a judge's order that the entire record in this matter, I'm guessing the California one, is sealed. It also stated that Wiseau had been informed by his California legal counsel that it is an offense to publish any content from a sealed file, and that sealing means the case contacts are legally considered to never have occurred and are not acknowledged by the state of California. Somehow I doubt that. Wiseau also stated that he had been advised once a Superior Court of California case record is sealed, a person listed as a defendant gains the right to deny or not acknowledge anything to do with the legal proceedings. I dismissed plaintiff's motion. I had no evidence that the defendants had improperly obtained or reproduced the court documents or copies of them, which may be obtained from many sources. Nor did I have admissible expert evidence on California law, which may reach any conclusion that admitting the documents and evidence was contrary to law. Further, later in the trial when Harper was cross-examined, he denied knowing that the California case was sealed. As well as noted, Wiseau had known of their use in the documentary for several years without taking any steps to object to their use in the lawsuit. In the end, however, these documents were of little, if any, relevance or value. Wiseau's first witness was Jean-Marie Spicuzza from Los Angeles. I'm guessing since she's from Los Angeles, she is Jean, who described herself as a producer, writer, director, actor, performer, fine artist, market researcher, product developer, consultant, chief executive officer at Seasons, and a muse, a 7th Division entertainment company and corporate conglomerate established in 1993.
A perfect match for Tommy Wiseau.
I would like a title like that, please. Let's work on a Leonard French title that is 4 lines long. Spicuzza provided a 2-page expert witness statement which discusses why the room is appealing to its audience. Okay. It also states her opinion that the defendants have somehow attempted to erroneously exploit the gains of the room and the disaster artist, and that they have wrongly outed Tommy Wiseau. Outed? That Roomful of Spoons fails to contain production values that are competitive in the present motion picture industry, and that she does not regard Roomful of Spoons as a proper documentary, but rather a tabloid or hit piece, a category that would not qualify it for fair use. As became clear in the cross-examination of her and others, Spicuzza has effectively run the trial for Wiseau, sourcing the other expert witnesses and obtaining their statements. With respect to her own report, Spicuzza says she instructed herself as to the scope of its content. She attended the entire 2-week trial, assisted Mr. Brinza frequently, eventually taking a seat at the counsel table with my permission, to avoid having to come forward to pass Mr. Brinza notes, and to provide him with information that might be helpful in the prosecution of the case. Can you imagine that? Like, you're at a trial, you're trying to defend, and like the executive producer becomes second chair co-counsel. Like, what? In making this observation, I am not being critical of Mr. Brinza. He took on this challenging case on short notice, and I am sure Spicuzza's assistance was valuable to him. In my view, Mr. Brinza handled himself very professionally, competently, and with integrity. When the judge starts complimenting your lawyer, they're about to tell you that your lawyer did a great job and we're sorry that you lost. Shari Hamrick Graywall has been in the film production and distribution business in Los Angeles for about 30 years. Graywall signed 2 affidavits prepared at Spicuzza's request, the first addressing her reaction to and concerns with the documentary, and the second one elaborating on issues relating to errors and omissions, insurance. E&O insurance. Much of Graywall's evidence seemed to seemed to simply assert a bias against Roomful of Spoons and the defendants. She stated that in her view, the documentary is too long, and that she found portions of it very uncomfortable to watch. You know, in my opinion, portions of this court case were too long, but I guess that didn't change anything, did it? Like Spikuza, Greywall stated that Harper should have been more respectful, and she disliked the fact that the documentary goes from being about the room to being about Tommy Wiseau, but she could not explain why that made it any less of a documentary. It was never explained why a documentary could not have the components and biases that Greywall described, nor did she define what a documentary is, other than to agree in cross-examination that the Academy of Motion Pictures defines a documentary as a nonfiction film, with the emphasis on fact and not fiction. On the other hand, Greywall agreed that the comments on The Room were interesting and the portions of the documentary were investigative. And when she was asked whether the documentary criticizes The Room, she said, "Doesn't everybody?" Doesn't everybody? Curiously, when asked if the documentary might have benefited from being released before The Disaster Artist, she said she did not know if that would have been allowed. She stated that the makers of The Disaster Artist would likely do anything to stop the release of Roomful of Spoons in advance of the release of The Disaster Artist. You know, I don't think so. I think that if this is a fair use in Canada, it is definitely a fair use in the States as well. Tommy Wiseau filed 2 affidavits, a declaration, and lengthy statements. Although not formally sworn, Wiseau asserted that the statements filed were sworn, and I have treated them that way. Wiseau's evidence was difficult to follow. No shit. His first statement of facts includes a proposed license agreement with the defendant's entity, Rockhaven Pictures, some correspondence with Harper, and many still photos from The Room reflecting clips and still photos said to be owned by the plaintiffs used in the documentary. He made assertions of illegal use of copyrighted material, unlawful downloading, malicious representation of the original materials, and the inclusion of unauthorized biographical data against the defendants, among other things. In his second statement of facts, prepared just a month before trial, Wiseau asserted, among other things, that the defendants had violated copyright and tampered with plaintiff's property. He complained that the information presented in Roomful of Spoons gives a negative impression of him in The Room, and asserted that the defendants pursued him against his will, mocked his ethnic heritage, and used expletives to refer to him. Wiseau disagreed with the description of Roomful of Spoons as a documentary, despite the fact that it is pleaded to be one in the statement of claim. He said it is a movie, not a documentary, though he did not explain why. Many of Wiseau's testimony, or much of Wiseau's testimony, was simply assertions without more. He avoided answering many questions and complained about the process. Wiseau gave lengthy, self-serving answers in his re-examination. He claimed, as he did in his written evidence, that the defendants had ripped the clips of The Room from a Blu-ray disc and tried to tamper with it. He asserted that ripping the film from a Blu-ray disc was hurting his product, that the clips were not presented at the highest quality, and that what he thought was going to be clips used for 1 minute and a trailer turned out to be 7 minutes, for which he feels he should have been paid. By the way, under U.S. law, I don't know what it is in Canada, but under U.S. law, we have exemptions to copyright law that are set forth every 3 years by the Register of Copyrights and the Copyright Office. And one of the exceptions is for documentary filmmaking, to allow them to rip or otherwise break tamper protection or technological protection measures to get the digital data off of a disc or out of a stream in order to make fair uses of it. Cynthian Sharp is a self-described documentarian that has made many documentaries, some of which are feature-length, and speaks on the subject at the University of California, Irvine twice a year. Sharp stated that documentarians might have a bias, unlike journalists who are, in Sharp's view, supposed to remain unbiased. I'll refrain from further commentary on that. Documentarians are trying to compel you to a point of view, he said. With respect to fair use, Sharp stated that in the film industry, one's presentation must not be reselling the original product in a slightly altered form, but must rather fundamentally change the presentation. We would call that the fourth fair use factor, market usurpation, and the first fair use factor, transformation. Sharp's letter criticized Roomful of Spoons for being about the creator, Harper, and his journey in exploring the making of the room and investigating Tommy Wiseau, which he describes as malicious. However, in cross-examination, Sharp described Roomful of Spoons as a compelling documentary that was well done. He said that watching Roomful of Spoons raised in him deep suspicions about Tommy Wiseau. Although he seemed to be critical of Harper for telling the story from his own perspective, Sharp acknowledged that this has become a documentary technique in which the narrator becomes the main character. He cited the well-known documentaries by Michael Moore as examples. Sharp said that watching Roomful of Spoons made him want to watch The Room, which he has not seen when he testified. Really? He hadn't seen it. He's testifying about it. He hadn't seen it. Sharp stated that while some people will not want to see The Room after viewing the documentary, many others will want to see it. He also agreed that a documentary commenting on another work is unlikely to be as popular as the original work. In response to questions about the amount of material from The Room used in the documentary, Sharp said that he might have used more than the approximately 7 minutes used by the defendants if he had been making the documentary. All of the defendants submitted affidavits and were cross-examined at trial. Ferrero-McGrath was questioned on his role as an editor and on using images of Tommy Wiseau, including on tickets for a screening of Roomful of Spoons in Ottawa and on the Kickstarter campaign. The defendants did this without seeking legal advice. They did their own research on copyright and fair dealing. Ferrero-McGrath confirmed that the only impediment to signing a distribution agreement was the injunction and the continuing lawsuit. He stated that the project was complete and ready to hit the theaters by January 2016, although he agreed the distributor might suggest additional edits. Ratchicott was the cinematographer or cameraman. He agreed the project evolved from its original objective of documenting the phenomenon of The Room and its fans to also including Tommy Wiseau, who he described as being synonymous with The Room and part of the phenomena. Harper was cross-examined at length. Harper confirmed that the defendants were of the view that they did not need Wiseau's permission to use clips of The Room. They did some research on fair dealing and fair use, spoke to some lawyer friends, and felt that they had a decent understanding of the law. Harper said they could not afford lawyers. Nevertheless, he agreed that they tried to reach a settlement agreement with Wiseau because it is always better to have an agreement. Harper stated that in one of his first discussions with Wiseau, he said he would charge $500 for the use of 3 minutes of The Room, but then sent an invoice for $5,000. Later, Wiseau said he would give defendants a student discount, all of which was confusing. Harper said he was willing to entertain Wiseau's ideas but wanted to respect his wishes, but that he kept coming up with new demands. For example, Wiseau demanded that it be edited to have more positivity by at least 60%, or to make it shorter, and that he simply wanted it to be an advertisement for The Room. Harper and the defendants felt Wiseau was deliberately making unreasonable demands to drag things out, making it impossible to continue to negotiate with him. Although Harper agreed that he could have made the film without using clips, that it would have been a different movie, and not as good of a movie. In Harper's view, the use of images from The Room and photos of Wiseau on Kickstarter, such as a picture of the billboard promoting The Room that Wiseau paid to have up in Hollywood for years, or on tickets for a screening, simply reflected what the project was about. With respect to what might have been done after the injunction was lifted, Harper said they still had a pending civil claim, and there were threats everywhere, which would have made it extremely difficult to release or even to show it at film festivals. The defendants continued to be in touch with Gravitas, but Harper said the company is not interested in the film until the legal issues are resolved. This action by Wiseau, Harper said, has therefore made it impossible to successfully release Roomful of Spoons while the suit continues. Harper said that he tried to be very balanced, noting that only 6 minutes of The Room is on Tommy's personal life. Only 6 minutes of the Roomful of Spoons film is on Tommy's personal life. Harper was an impressive witness. He answered questions forthrightly and directly. He was cross-examined at length, and his evidence was consistent with his affidavit and the written record. I had the same impression of each of the defendants. The defendants called an expert in calculating intellectual property damages, Doug Bania. Bania is an intellectual property consultant in California. He has been qualified as an expert witness in 65 cases in the United States dealing with intellectual property issues, including damages. Bania was unable to provide any opinion on plaintiffs' alleged damages due to their failure to produce relevant documents. I accept this conclusion. In addition to the plaintiff's failure to produce the assignment of copyright in the room to Wiseau Studio, which is pleaded in the statement of claim, they have also failed to provide any information about revenues from the room or its related merchandise, and they have failed to provide the full agreement involving Wiseau's sale of his life rights to SZ Books relating to Franco's production of The Disaster Artist. The plaintiffs have, therefore, not produced any financial information whatsoever to conclude that they have suffered or will suffer any damages from the release of Roomful of Spoons. Indeed, it is quite possible, as suggested by the plaintiff's expert Cynthia Sharp, that Roomful of Spoons might create more interest in the room, and, should it be released in the future, the plaintiffs may well benefit from it. In order to consider whether and to what extent Roomful of Spoons would have benefited from The Disaster Artist had it been released in 2017 prior to the release of Disaster Artist, Bania considered 3 comparable situations in which documentaries had been made about feature films. 1. Best Worst Movie and Troll 2. 2. Jodorowsky's Dune and Dune. And 3. American Movie and Coven. American Movie grossed over $1.165 million, ranks 183rd on the list of all films with the documentary genre label. Jodorowsky's Dune grossed over $647,000, and Best Worst Movie grossed almost $110,000. These are US dollar figures. Due to the success of The Disaster Artist, including its Golden Globe Award and nomination for an Academy Award, Bania believes that the range of comparables is a conservative indication of the revenue Roomful of Spoons might have achieved. In his view, Roomful of Spoons would likely be at the high end of the range of revenues achieved by the comparable documentary films, or an amount around $1.1 million US dollars. This is a conservative estimate. Bania also considered the draft agreement with Gravitas and its fees totaling approximately 40% when distribution and marketing expenses are included, and concludes the Roomful of Spoons, Inc. would have achieved earnings of about $660,000 US dollars from its production of Roomful of Spoons. Bania's analysis was not seriously challenged on cross-examination. Indeed, some of it focused on the ongoing success or buzz associated with the room, but this only adds to the buzz that Roomful of Spoons might have experienced since. As Bania also stated, watching one makes you want to watch the other. Issues. The statement of claim raises many causes of actions. However, some of these either have been abandoned or not pressed at trial. These include claims by the plaintiffs for breach of contract, fraudulent misrepresentation, and trademark violations. Consequently, the issues that need to be addressed are as follows: breach of copyright, including whether fair dealing applies, the defendant's counterclaim, and damages. Who owns the copyright? The starting point of a copyright case is to determine who owns the copyright. Section 13.1, this is Canada, of the Copyright Act provides that the author of a work shall be the first owner of the copyright therein. Copyright may be assigned to another, but the law requires an assignment, whether wholly or partially, to be in writing. In this case, the statement of claim states that the plaintiff, Wiseau Studio, is the copyright owner in the plaintiff's works at issue. It also states that Tommy Wiseau assigned his rights, title, and interest in the room and in all related works to Wiseau Studio. However, the defendants have denied this assignment to Wiseau Studio in their statement of defense, putting a burden on the plaintiffs to prove the assignment. The statement of claim attaches copyright registration certificates, which state that the owner of the copyright is Wiseau Films. These certificates have not been made exhibits or otherwise proven at trial, but they do not establish that Wiseau Studio has been assigned the copyright, as that entity is not mentioned. Wiseau Films, on the other hand, seems to be the name under which Tommy Wiseau does business, at least according to the title of proceedings on the front of the statement of claim. Accordingly, there is no evidence of an assignment of copyright to the plaintiff Wiseau Studio, and I agree that the corporation's claim for copyright infringement should fail on that basis. Further, given Wiseau's admission that he be assigned copyright to another entity, or that he did assign it, Wiseau Studio, his claim on its face should also fail on that basis. This seems an odd result, that the claim should fail because the creator of the work, and Tommy Wiseau is identified as the author of the work on the registration, has pleaded that he has assigned the copyright to the other plaintiff, but he has failed to prove it. However, the law of copyright may come to the plaintiff's aid. It provides, in any civil proceeding taken under this act in which the defendant puts in issue either the existence of a copyright or the title of the plaintiff to it, copyright shall be presumed, unless contrary is provided. In this case, the defendants have put the existence of the copyright and title to it in issue. They argue that the evidence shows there are multiple authors of the film, as demonstrated in the documentary, in which, for example, Sandy Schler claims to be the director, and it is asserted that many scenes were essentially improvised. There is also an absence of any evidence of assignments from actors, the composer, film editor, or the crew who provided services in creating the room. Although the pleading confuses the issue and raises doubts as to who owns the copyright in the room and related works, the room is presented as a work by Wiseau Films and Tommy Wiseau. Wiseau wrote, acted in, and produced the room, and is inseparably linked to it as its creator and author, a term which is used many times in the Copyright Act but is not defined in it, and which, in my view, must be given a generous interpretation. Tommy Wiseau, therefore, is the creator of the room, and it is in his interest that the Copyright Act is meant to protect, absent an assignment. Thus, while the plaintiffs themselves have raised doubts about the ownership of the copyright, having regard to the Copyright Act, the way in which this case is presented, and the absence of evidence rebutting the presumption, it seems to me the prudent course is to accept that the plaintiffs have standing to address whether the copyright is infringed.
See, this part is crazy to me, because the judge has to spend a whole page going over whether or not he owns the copyright.
Yeah.
When Tommy Wiseau is the plaintiff, this is his own lawsuit that he's not cooperating with.
Mm-hmm. I mean, heck of a thing to file such a lawsuit and then not cooperate in it. Section 3 of the Copyright Act grants an owner... excuse me. You have to have a coughing fit in the middle of a live stream. Section 3 of the Copyright Act grants an owner the sole right to produce or reproduce the work or any substantial part thereof. Not every copying of a portion of a work, therefore, constitutes an infringement. To make out a claim of copyright infringement, the plaintiff must first demonstrate that the defendant's use of copyrighted material constitutes a substantial taking from the copyrighted work. The taking must be substantial because the purpose of the Copyright Act is to strike a balance between promoting the public interest in the encouragement and dissemination of works in the arts and intellect and obtaining a just reward for the creator. Sounds an awful lot like Article 1, Section 8, Clause 8 of the U.S. Constitution, where copyright is to promote the sciences and the useful arts. So is patent, by the way. A substantial part of a work is a flexible notion. As a general proposition, a substantial part of a work is a part of the work that represents a substantial portion of the author's skill and judgment expressed therein. As a general matter, it is important not to conduct the substantiality analysis by dealing with the copies featured piecemeal. Rather, the cumulative effect of the features copied from the work must be considered to determine whether those features amount to a substantial part of the skill and judgment expressed in the work as a whole. Wiseau's ideas are not copied and passed off as the defendant's work, but there is no question that clips from the room are used in Room Full of Spoons. In fact, that is what much of the documentary is about. 7 minutes of content from the room, which is 99 minutes long, was used in the 109-minute long documentary. There are 69 separate clips used, and the longest clip is 21 seconds. This is not a trivial amount of the room. In my view, Roomful of Spoons does reproduce a substantial part of the room within the meaning and intent of the Copyright Act. While the amount is not large compared to the length of the film, the documentary would not be the same without the number of clips used, and this amount of use cannot be regarded as trivial. I reach this conclusion with some reluctance because Roomful of Spoons does not seek to replace or copy the room, nor does it purport to copy Wiseau's skill or judgment, or diminish the value of his work, or to pass off his work as the defendant's product. Rather, the clips are used to talk about Wiseau's work with all of its flaws. However, the issue of whether the use of plaintiff's material infringes copyright is best addressed in the context of fair dealing, which I address below. Fair dealing is often described as a defense to copyright infringement, as the onus lies on the defendant to establish the use of the material constitutes fair dealing. However, the Supreme Court has noted that it is better described as an exception to infringement and a user's right rather than a defense. So even in Canada, fair use is both an exception to infringement and a right rather than a defense. It is intended to balance the rights of creators and innovators to disseminate and profit from their work with the public interest in receiving, debating, and benefiting from creativity and innovation. It must therefore be given a generous scope. Procedurally, a defendant is required to prove that his or her dealing with a work has been fair. However, the fair dealing exception is perhaps more properly understood as an integral part of the Copyright Act than simply a defense. Any act falling within the fair dealing exception will not be an infringement of Copyright Act. Of the Copyright Act. The fair dealing exception, like other exceptions in the Act, is a user's right. Users' rights are not just loopholes, but owners' rights and users' rights should therefore be given the fair and balanced reading that befits remedial legislation. The test for fair dealing requires the defendant to prove that A, the dealing was for one of the allowable purposes listed in the Act, and that the dealing was fair. Whether the dealing is fair is a fact-specific inquiry which may be considered having regard to the following factors. Remember, factors are part of a balancing test. We're going to balance the following 6 fair dealing factors. You're learning a whole other set of fair use law. Look at this. 1, the purpose of the dealing. 2, the character of the dealing. 3, the amount of the dealing. 4, the alternative to the dealing. 5, the nature of the work. And 6, the effect of the dealing on the work. Isn't that nearly a mirror image of U.S. fair use law, 17 U.S.C. section 107? The only thing we don't have is the alternatives one. Although it sort of comes in there, like the judge can definitely argue it in there someplace. The purposes of Roomful of Spoons is to critique and review the room. The defendants also submit that the documentary constitutes news reporting as it informs viewers of facts about the film and Wiseau. The dealing is therefore for an allowable purpose. The plaintiffs take issue with the purpose of Roomful of Spoons, asserting that it is not a proper documentary, but rather a tabloid-style expose or hit piece intended to prejudice the honor and reputation of Tommy Wiseau. Ms. Spicuzza testified that the purpose of documentaries is to enlighten, educate, procure, or promote a cause, and must be balanced and respectful of their subjects. I am not sure where this definition comes from, and in any event, I must reject it. As noted earlier, the Academy of Motion Pictures defines a documentary as a nonfiction film, with the emphasis on fact and not fiction. The Academy's definition does not require a documentary to enlighten and educate, though it is to be expected that most will do so given their emphasis on facts. Nor does it require that such a film procure or promote a cause, although many undoubtedly will. Indeed, Spicuzza conceded that documentaries might have a point of view. Whether or not the plaintiffs regard Roomful of Spoons as a tabloid-style expose or a hit piece, or contains facts Wiseau would prefer not to be disseminated, has little to do with whether the first step of fair dealing has been met. Leaving aside the fact that such a requirement would raise concerns about limits on freedom of expression produced by the law of the Canadian Charter of Rights and Freedoms, even if the documentary is not respectful of Wiseau in that it denigrates his skills as an actor and filmmaker, that constitutes criticism and review. There is nothing new about such criticism of Wiseau and his movie, as Ms. Greywall testified. Everybody criticizes The Room. If Wiseau does not like how he is portrayed in Roomful of Spoons, his claim may be for defamation. If the fair dealing is for the purpose of criticism, and that criticism may be strongly expressed and unbalanced without forfeiting the fair dealing defense, an author's remedy for malicious and unjustified criticism lies, if anywhere, in the law of defamation, not copyright. However, Wiseau is not sued for defamation, perhaps because the documentary is on a matter of public interest, as that term is used in defamation law, and he cannot point to any factual errors in the film, or identify any comment that is not based on fact, making the success of a defamation claim rather unlikely. The plaintiffs also assert that the scenes depicted are the film's best, most popular, most iconic, most recognizable scenes, suggesting, it seems, that this was not for the purpose of review and criticism, but for some other, perhaps commercial purpose. While the scenes from The Room used in Roomful of Spoons may well be popular and recognizable, perhaps even iconic, when asked about this, Harper said that every scene in The Room is iconic. Whether or not the documentary reproduced clips from what the plaintiffs describe as iconic scenes, some parts of the film seem to cry out for attention, such as Wiseau's poor acting in the "Oh hi Mark" scene on the roof, or when Wiseau yells, "Lisa, you're tearing me apart," doing his best imitation of James Dean in the 1955 film classic Rebel Without a Cause. Although, accordingly, the plaintiff's claims about the selection of clips does not assist their position, given my finding that Roomful of Spoons and the use of the plaintiff's material in it had as its purpose review, criticism, and news reporting. In short, a documentary can be many things and can be positive or negative about its subject. To the extent that a documentary uses copyrighted material for the purpose of criticism, review, or news reporting, then such use is for an allowable purpose under the fair use or fair dealing provisions of the Copyright Act. Roomful of Spoons meets each of those purposes. Having found that the plaintiff's material falls into one of the allowable purposes for fair dealing, I consider the 6 factors below, set out in the CCH case, to determine whether that use was fair, following the approach the Supreme Court used in CCH. Purpose of the dealing. As described above, the purpose of the documentary and its use of the plaintiff's material are to provide review, critique, and information about The Room, the phenomenon it has created, and the maker of the film, Tommy Wiseau. This is a permitted purpose. The copying was not for a commercial purpose, but simply to make a documentary. The defendants had no expectation when making the documentary that they would profit from it, nor did they appropriate The Room to that benefit. Character of the dealing. This factor addresses how the copyrighted material is dealt with by the user. In doing so, it may be relevant to consider the custom or practice in the particular trade or industry to determine whether the character of dealing is fair. In this case, the copyrighted material was almost invariably accompanied by commentary, illustrating or supporting points made by the narrator or interviewees. This is a common technique in documentaries and in providing review and criticism. Use of the clips for purpose of commentary is a character of dealing that is appropriate and supports a conclusion that the dealing was fair. The amount of the dealing. In considering this factor, the court must look at both the amount of the dealing and the importance of the work allegedly infringed. While the documentary's use of footage from The Room is not trivial, it is also not excessive. Roomful of Spoons, which is 109 minutes long, uses 7 minutes of footage in 69 short clips from The Room, which is 99 minutes in length. This is less than 7% of the source work, and an even smaller percentage of the documentary. The longest clip is 21 seconds. Further, Roomful of Spoons has a number of components and is not just about the room or copyrighted material. Rather, it informs viewers about the experience and culture surrounding the room and its fans, about the making of the film by those involved. It also provides information about the mysterious Tommy Wiseau. While use of expert excerpts from the room and some of the other material belonging to the plaintiff is important to conveying the material or message in the documentary, such use is limited and linked to the objectives of the documentary. The purpose of the copying was not to replace the room. Therefore, the amount of the plaintiff's work is not excessive, does not support a conclusion that the fair dealing exception does not apply. Alternatives to the dealing. This factor considers whether there is a non-copyrighted equivalent of the work that the defendants could have used instead of the copyrighted work to achieve the objectives of the user. In this case, this factor has little application. Roomful of Spoons is about the room and Wiseau. There is no alternative to the copyrighted material that makes the points that were made. As Harper stated, without the clips, it would have been a different film. As to the alternative of obtaining licenses to use plaintiff's material, as the facts demonstrate, it was impossible for the defendants to obtain licenses without giving up editorial control. This is one of the reasons the fair dealing exception exists, as observed by the Supreme Court of the United States in Campbell v. Acuff Rose Music, the 1994 case where Justice Souter noted that the unlikelihood that creators of imaginative works will license critical reviews or lampoons of their own productions removes such views or uses from the very notion of the potential licensing market. In other words, you don't have to consider alternatives when it's a critical work, because who would license for critical work in the first place? You would never get a license for a critical work anyway. The nature of the work. This factor considers the nature of the copyrighted work and the extent to which it has already been disseminated. If a work has not been published, the dealing may be more fair in that its reproduction with acknowledgement could lead to wider public dissemination of the work, one of the goals of copyright law. If, however, the work in question was confidential, this may tip the scales towards finding that the dealing was unfair. So this is about published versus unpublished works. In this case, the material was not confidential, nor is it unpublished. Quite the contrary, it has been widely available for 2 decades, plays frequently in cinemas, is available free online. There is no evidence that Wiseau has attempted to stop such access or piracy, and has been viewed online over 1 million times. In my view, this factor favors the defendants. Effect of the dealing on the work, the market usurpation factor. If the reproduced work is likely to compete with the market of the original work, this may suggest that the dealing is not fair. However, the court cautioned that while the effect of the dealing on the market of the original copyright owner is an important factor, it is neither the only factor nor the most important factor that a court must consider. The plaintiffs allow that the documentary is a derivative work, but submit that it is nevertheless competitive with the room. Both plaintiff expert Cynthia Sharp and defense expert Doug Bania commented that the documentary is a competitive product. However, the documentary covers many of the room's most iconic scenes. This may lead viewers to conclude that, having seen the documentary, there is no need to see the original. In my view, Roomful of Spoons is not an alternative to The Room, and does not replicate or replace the unique experience of attending a showing of the original work, where people dress up as characters in the film, throw footballs around, throw spoons, and shout at the screen. Watching Roomful of Spoons is more likely to create interest in The Room than to compete with it. I mean, I kind of admit just reading this here has made me want to go watch Roomful of Spoons and The Room. Which,
yeah, we might have a staff.
I don't think I actually watched The Room ever. I'm trying to remember. I think I've just seen a whole bunch of clips of it, and that's why I have a vague idea of having watched it.
Let's commit like this Saturday or something to sit down and watch it together.
We'll host an online screening and get permission from Roomful of Spoons. Further, the fact that festivals and cinemas have been interested in playing double features of The Room and Roomful of Spoons together suggests that the films complement rather than compete with one another. There is no evidence that the limited screenings of the documentary may have had any negative impact on The Room. To the extent that there may be a negative impact, which is entirely speculative, it would be more likely due to the film's criticism of The Room and Wiseau, and the reporting of facts about him, but that does not make the dealing with his work unfair. My discussion of the requirements of fair dealing and of the factors to consider in determining whether specific use can be considered fair leads me to conclude the fair dealing exception to copyright infringement applies in this case. And then we skip way ahead. Thank you so much, Tactical. And the judge begins damages. Punitive damages are exceptional and must be awarded with restraint. They are limited to cases where a litigant's conduct is malicious, oppressive, and high-handed, and offends the court's sense of decency. Awards of punitive damages may be made where the misconduct is a marked departure from ordinary standards of decent behavior. The object of awarding punitive damages is to punish the guilty party rather than compensate the innocent one. In my view, an award of punitive damages is justified in this case. The plaintiff's conduct has been oppressive and outrageous towards the defendants over many years and in this lawsuit. The plaintiffs engaged in bad faith negotiations with the defendants in order to delay or prevent the release of the documentary when it likely would have received much attention and accolades. In doing so, the plaintiffs were concerned with protecting and maximizing the value of the disaster artist in which the plaintiffs have a financial interest. This effort even continued at trial when the plaintiffs sought to have consideration of the disaster artist excluded. Most notably, however, in purporting to continue negotiations, the plaintiffs requested that the defendants delay the documentary's release, which they did, so that the plaintiffs could use that delay to prepare for and obtain an injunction. An injunction obtained ex parte and based on misleading and incomplete material, which prevented Roomful of Spoons from being released around the same time as the disaster artist. Wiseau then refused to attend for cross-examination on his affidavit, and he has not produced any financial information relating to the disaster artist. The plaintiffs also made misrepresentations to third parties about the legality of screening the documentary and conducted the Shame on You campaign, which wrongfully accused the defendants of illegal conduct, including stealing material from Wiseau. This conduct prevented the defendants from raising money on Kickstarter, and the injunction and ongoing litigation effectively destroyed the defendants' years of work, developing a profile for the Roomful of Spoons project on social media. Wiseau also accused the defendants of filing perjurious affidavits, though he never identified what was allegedly false. Despite this, he asked the case management judge to direct the Crown Attorney to prosecute the defendants for perjury less than a month before trial was to commence. Wiseau also made misrepresentations to the court regarding his availability for trial. Further, in considering an award of punitive damages, I am mindful that the defendants intended in early 19 to bring an anti-SLAPP motion. Had they done so and been successful, and had the judge found that the action was brought in bad faith, the defendants would be entitled to damages. While this is not an anti-SLAPP motion, the ability to obtain damages in such circumstances is recognition of the wrong caused by actions which have the effect of infringing a defendant's freedom of speech. In my view, this action was brought for the improper purpose of preventing the release of a documentary disliked by Tommy Wiseau. None of his causes of action had any merit. In my view, the deliberate infringement on the defendant's freedom of speech caused by the plaintiff's actions also supports an award of punitive damages. I conclude that an award of Canadian $200,000 is appropriate to punish the plaintiffs for their egregious conduct. As with the compensatory damages, the punitive damages are awarded to the corporate defendant, plaintiff by counterclaim, Roomful of Spoons, Incorporated. The plaintiff's claim is dismissed. The counterclaim of the defendants is granted, and the plaintiffs shall pay to the defendant, Roomful of Spoons, Inc., US $550,000 in compensatory damages, plus Canadian 200,000 in punitive damages, or approximately another 150,000 in US dollars. The defendants are entitled to their costs, so also the defendants' attorney's fees and costs. The defendants shall provide me with a brief written submission on costs within 30 days of the release of these reasons, and the plaintiffs shall provide a response within 30 days of the receipt of those submissions. Submitted April 23rd, 2020 by Justice Shabas of the Superior Court of Ontario. Holy mackerel, what a fun read that was. I was just gripped by that the entire time. Normally, I'm not so gripped. Yeah. Thank you, everyone, for the support over the years, says Roomful of Spoons, to our incredible legal teams at Denton's Canada and Taylor, Obala, Murray, and Leyland, and I guess the U.S. I'm not sure. I guess maybe they're both in Canada, I guess. Thank you all for having faith in our case and bringing your best. There's a lot to sort in this case, especially amidst our current pandemic apocalypse situation. If we can ask a favor, please give us a bit of time to get everything in order. We absolutely want to get this film out ASAP, but please understand we want to do it the right way, which sometimes takes a moment. We'll keep our supporters in the loop as we move forward. The Roomful of Spoons team. That's really cool. So now they're going to seek that distribution agreement, hopefully with Gravitas, or, you know, when a large independent film producer. There's a film festival that would normally be going on right now that I run a projector for. I'll talk to our people and see if we can get a screening of Roomful of Spoons done for, I guess, it might be too late. It might be out by then. But maybe by next year, or maybe whenever they do hold the film festival. This is really cool. I'm looking forward to seeing this documentary now that I've read all about it and learned all about their plight. We do not know what the attorney's fees are going to be, Zach. Thank you for the $2. Zach C., thank you. We do not know what the attorney's fees are going to be. In a case that's taken this long, I am betting hundreds of thousands of dollars. I'm going to guess another $250,000. I'll give myself some wiggle room and say that I don't know whether that's US or Canadian dollars. How about that? Also, I have some super chats to thank. Thank you very much to Willie Czar for the $2. Thumbs up, please. Yes, please give us a like and subscribe. Thank you to Amakiaria for the $5 and your laughing fox or laughing cat animation. Thank you, Alatania K, $5. The Room, the madness that keeps on giving. Thank you to Richard Hunt for $9.99. Lawsuit, you're tearing me apart. Thank you very much to all of those Super Chat supporters. So, do we have any thoughts? I have a crew with me here. I have Brandon, and I think I have Tactical with me. What do you guys think?
Chicken, Peter. You're just a little chicken. Cheap, 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 cheap.
I don't get the reference. What's that from? Is that from The Room?
It's from The Room.
I see. Yeah. I didn't watch it, did I? Because I don't remember any of the references.
See, this I love because I don't actually know anything about Canadian copyright law, which is great because people ask. I'm like, no, I only know American law stuff.
Because you work for me.
I work with an American lawyer. So now I got to learn about Canada's side to this, which is great. But I'm also just mystified at the lack of cooperation that Wiseau has for his own lawsuit that he's the plaintiff for. Like, I understand a defendant not showing up and defaulting, but he's the plaintiff and he didn't show up. Like, yeah.
I mean, yeah. Obviously, it was an attempt. It was a slap. It was a strategic lawsuit against public participation. It was an attempt to take down the documentary. I bet you he'd be perfectly happy if the documentary didn't exist and nobody ever said anything unkind about him. I get it. I mean, I don't like it when people say unkind things about me, but he could also have looked at it as like a positive thing, like it's just going to lead to more sales of The Room and The Disaster Artist. And then, every one of those sales, he gets 25 cents or whatever, whatever his cut is. So
here's another one for the chat. Leave your stupid comments in your pocket. But actually leave them below.
I did not lose that lawsuit. I did not. Oh, hi, Mock.
It's okay, Tommy. You can come out. They're gone now. In a few minutes, bitch.
Oh, the human brain, everyone, is just so interesting when it doesn't function properly.
I'm also kind of impressed at how they figured out actual damages. Like, I've never seen someone actually go through that calculation, because how do you predict how much a movie would have made if it was released?
Oh, yeah.
Like, because it's pure speculation, but they managed to get enough evidence together to say, this is our best guess. And I kind of want to be that expert witness that says, like, this is a guess.
And well, you saw how he did it. Doug Bania compared the thing to 3 other documentaries that had co-released with a feature film. And using their numbers, he came up with the 1.1 million gross, which I think might actually be a little bit low. But I guess time will tell.
John Gingrich says he just caught up to our stream. He was watching in 2 times speed and tried to catch up to the end.
Excellent. Welcome to the future. The future is now. All right, so as you all know, this is a community-supported legal education channel, so get your super chats in, get your sponsorship in on patreon.com/ljfrench or sponsors.com/law. Here, we'll play this. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Thank you very much to our May $50 plus supporters: Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Q, Grills in Your Area, Longreach Jones, Zachary Chaney, I have to take a breath, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. All of the $5 plus supporters are scrolling on the LED panel back there. Thank you to John Gingrich for the $5. Love you all. He says, love you too, John. Thank you for everyone coming, watching our. Has this been a documentary about the lawsuit about the documentary?
Hold on. We just made. All right. We just made an hour and 45-minute stream about an hour and a half documentary about a 90-minute film.
Yeah.
An hour and a half film.
Yep.
Okay.
And we did it live. We did it live, bitch.
Jesus.
All right. That's all I have for you today. I'm going to keep it short at an hour and 41 minutes. I said it was going to be about an hour. I thought maybe it was going to be about an hour and 15. No, it was an hour and 40.
I'm glad we did this live on YouTube, actually.
Yeah, because Brandon was going to have to edit this if I didn't do it live. So it worked out for everybody. Anyway, definitely like, subscribe, and share that. We want to get this, that lawsuit was just as much fun as those movies, and I'm hoping just as much fun as a documentary. So share it, because I think people would also agree, would also want to watch our live stream here. Yes, this is live Surreal JC Games. We're just that professional. Live in my... Do I have anything behind me I don't want you to see? Live in my studio here. So
Leandro wants to know what the percentage of positivity is in this video. I would say it's like 80% positive.
80% positive, yeah. So, all right. Well, I'm going to go play video games with my crew and have a good evening. You guys have a good evening, good night, good tomorrow. We'll let this play for tomorrow, and we'll drop another video on Saturday. I'm Leonard French, your favorite copyright attorney. I love you all. I will see you in the videos that drop. Thank you to Tack and Brandon for being here. Thank you to Tack for highlighting all of that. That was what Tack did. She read through that entire thing and highlighted every line that I read there so that I wouldn't have to read all 53 pages. We'd be here for another hour. So thank you. Love you. Bye.